Morning. I don't know what terrible things you've done in your life up to this point, but now your karma is out of bounds to get assigned to my class. I'm Professor Anastasia Keating, and this is Tort Law, or as I prefer to call it, How to Get Away with Tort. I'd like to start with a short quiz, and my first question is, of course, what is tort? You.
Tort is a wrongful act that causes harm to another person, for which the injured party may request damages.
That's right. And what are the heads of tort? Now, you.
Negligent, intentional, and strict liability torts.
Do you know any categories of torts?
Trespass to a person, including assault, battery, defamation, libel or slander, false imprisonment, nuisance, negligence, which means the breach of duty of care that causes harm to a person, and so on.
As it is clear, the main aims of torts are to provide relief for the harm suffered and also to deter potential tortfeasors from committing torts. So, what kinds of remedy do you know?
The injured person may sue both for an injunction or damages, compensatory and punitive.
Exactly. Torts are handled by civil courts, where the injured party brings an action in torts against tortfeasor. There is also an opportunity of out-of-court settlement. But firstly, we have to learn how to interview our client. Do you know something about WASP approach? You.
This is a special approach of interviewing client. The aim is to make sure that nothing is left out.
Yes, but to be more specific, this is the abbreviation of 4 stages. What are they?
If I'm not mistaken, these are welcome, acquire information, supply information and advice, and part, which means a conclusion.
You are not mistaken. So, here we have.
On the first stage, which is welcoming our client, we need to meet, greet and sit our client and explain the purpose of the meeting. Then we acquire information. Use open questions to encourage your client to tell you their version of situation. Periodically summarize what your client has said so far and don't forget to use sympathetic body language and active listening techniques. Then use closed questions to confirm understanding of what your client has already told you. On the next stage, supplying information and advising, we consider the merits of the case, legal and non-legal options, risks of taking legal action. Explain what action must be taken. The last stage is part. Confirm that your client is going to continue working with you, his understanding of risks involved, and check that your client has no further questions.
What are the types of negligence? The first is duty of care, duty to be reasonably careful while performing acts that could foreseeably harm others. A reasonable person would consider the burden of taking precautions, the likelihood of harm, and the seriousness of the harm that might be caused. Breach, conduct that breaches duty of care. Causation includes both cause and fact, actual harm caused by defendant's actions, and proximate cause, the event that is deemed to be the cause of the injury. Damages, actual damages that are suffered by plaintiff. Then we have following defenses of negligence suits. The first is assumption of risk. Plaintiff voluntarily and knowingly assumed the risk at issue inherent to the dangerous activity in which he was participating at the time of his or her injury. And contributory negligence. Plaintiff's actions kill the defendant's liability. As we can see, here we have all of the elements of negligence, but it was plaintiff's fault to push the defendant, so his own actions led to the harm he suffered, which can be considered as contributory negligence.
Our client is a manufacturer of medication. He was sued on the grounds of manufacturing goods that harmed consumers' health, which is a product liability.
Strict liability makes a defendant liable for harm caused by their products or activities regardless of fault. Defenses of strict liability suits are assumption of risk, comparative fault. If the plaintiff is involved in causing their own harm, the court will reduce the amount of damages awarded to the plaintiff in accordance with the percentage of harm that was self-inflicted. Misuse or abuse of the product means that the plaintiff used the item in a way for which it was not intended or reasonably foreseen. Thus, the defendant is not responsible for the plaintiff's injury. The plaintiff knew and voluntarily assumed the risks associated with an abnormally dangerous activity or a product, such as taking a medication while knowing about the side effects. In other words, the plaintiff consented to being harmed by the defendant. This should be considered as assumption of risk.
So, moving next, what types of intentional torts do you know?
Assault, battery, false imprisonment, and intentional infliction of emotional distress.
That's right. Does anybody of you have any examples of such kind of torts?
My aunt was accused of shoplifting and was locked in the service room by the shop manager. As far as I can guess, it was an act of false imprisonment.
So, how would you defend the shop manager?
As far as I know, a shopkeeper may detain a suspected shoplifter on store property for a reasonable period of time, so long as the shopkeeper has cause to believe that the person detained in fact committed or attempt to commit theft of store property. That is called shopkeeper privilege.
Very, very good. So, please, more examples.
When I was at school, my classmates agreed to meet after the school after fight. One of the boys kicked another boy and his nose started bleeding. And that boy's parents wanted to sue that boy on the grounds of battery.
How would you defend the boy?
I would say that there was voluntary combat, where the plaintiff engages in a fight with the defendant for the sake of fight, not as a mean of self-defense. The plaintiff may not recover for an assault or battery unless the defendant beat the plaintiff excessively or used unreasonable force, and he didn't.
Great. There are also such defenses for intentional torts as consent, police conduct, self-defense, defense of property, and provocation. This is the end of today's class. Now you're amazing lawyers who know how to get away with tort.
In legal trouble? Better call Anastasia, and we will fight for you.
Anastasia Civil Attorney Office, 312-435-2243.